Gilbert Squires, and I'm with the law firm of SquiresBenson. My partner, Olivia Benson, is here, and we are on behalf of the appellant, Jaime Eisten. The issue here, judges, is whether you get to review the alleged return of service de novo. And here we're looking at Mr. Eisten, who was purportedly served in Israel when he was not even in Israel at the time of service.
That is a case, that is an issue in dispute.
Indeed, Your Honor. And because it is an issue in dispute, it should have been properly addressed and looked at either through an evidentiary hearing, or it should, by this court, be reversed and quashed.
We certainly cannot resolve an issue of that.
Understood.
The question is, did the trial court resolve an issue of that, or did he say that the only showing, which was not supported by your client in person, that had some pieces of paper that indicated that he was not in Israel, but left something to be desired insofar as their official, completeness and whether it was correct or not, whether he said that the presumption of correctness in the return had been overcome under those circumstances. And that's a matter of law, isn't it?
It is a matter of law as long as the return is exactly correct on its face and it fulfills the requirements of Florida statute. And more importantly, we're talking not only of local Florida statute, we're talking of the long-arm statute. Additionally, there was an affidavit.
Well, what did you raise below that contravenes the facial validity of the return? What did you raise below? Not here in your brief, but below.
We raised the issue of jurisdiction, Your Honor.
But not the facial validity of the return of service.
Not at the first hearing, Your Honor. In fact, our intention on the motion for rehearing, which we got also the affidavit from the apostle from the Israeli Ministry of Interior that confirmed that Mr. Eisten was not there.
Yes.
Our focus was the fraud, Your Honor.
But so the initial hearing, you did not contravene the facial validity of the return.
Not in detail, Your Honor.
So then no, you didn't at all.
But we raised the issue of the jurisdiction, the lack of the jurisdiction of the court, Your Honor.
I'm talking about the facial validity of the return.
This is not the jurisdiction.
Because we've got if we don't get past that, we can't figure out who's got the burden to come forward, right?
Yes, Your Honor.
So the ultimate burden of establishing jurisdiction is on the plaintiff. The burden of coming forward in the face of a facially valid return is on the defense.
But once the defense raises...
This is not a matter of subject matter jurisdiction. This is a matter of personal jurisdiction.
Well, it becomes a matter of personal jurisdiction once the defense, Your Honor, in this case, raises a question about whether he was actually served, whether there was fraud being presented on the court.
Right.
And that's
by clear and convincing evidence.
And by clear and convincing evidence has to be looked at with the totality of the information. One of the things that Mr. Eisten did not have at the time was additional confirmation from the Israeli Ministry of Interior that arrived subsequently.
My problem is that Baxter asked for a continuance to have an evidentiary hearing, and you or your client opposed the request and said, no, we want to proceed. And now, after you lose, then you want to present additional evidence through a motion for rehearing. I have a real problem with that procedure. You committed to going forward, and you lost. That should be, if you can show that at that first hearing, the judge made a legal error, but she made a determination that you did not overcome the presumption of the initial return of service, and that you're stuck with.
Well, His Honor is reading and agreeing with Appellee's brief. One of the things that Appellee's brief did not indicate was that there had already been a continuance. In fact, the hearing had initially been set for early January.
Am I incorrect in saying that at the hearing, They asked for a continuance. You opposed it, so they went forward. You did not challenge the return, therefore it was your burden to come forward with clear and convincing evidence of no service, and the judge ruled against you. So as to the factual issue of where Mr. Einstein was, if he was out of Israel or not, that was resolved by the trial judge in favor of Baxter. So now we're stuck with only looking at whether there was a legal error committed.
And part of His Honor's analysis must include that my statement below was not that there was so much an objection as to that motion for continuance. There had already been delay, and more importantly, that the person that we believe needed to be examined, in addition to Mr. Einstein, was the process server who purportedly served Mr. Einstein when he wasn't there, who did not comply with Israeli internal law, and Israeli internal law specifically said what he needed to do, and we addressed that below insofar as him saying that he went there 3 times, and curiously he did not fill out the affidavit where the spaces required stating that he needed to, the times that he went and purportedly served Mr. Einstein. And additionally, Israeli internal law did not allow the process server to just say without more that that's how he served Mr. Einstein.
Did you raise all this at the initial hearing or the motion for rehearing?
In fact, at the initial hearing, we raised it through the affidavit of Mr. Adam Jorno, who is Mr. Einstein's Israeli counsel. And Mr. Adam Jorno's affidavit specifically stated those things that needed to be done and were not complied with.
That's not subject to cross-examination. That is not valid evidence.
That's absolutely correct, Your Honor. It's not subject by itself to cross-examination. However, if you add it to Mr. Einstein's affidavit, Mr. Einstein's passport, that was not objected to, and by the way, came in as a true copy of the passport. He is an Israeli citizen with dual U.S. Israeli citizen who made Aliyah, who by making Aliyah was required under Israeli law to come in with his Israeli passport. The court below was told that that was not the case, that there was some type of biometric system that was in place, and it was not in place here. All those things, Your Honors, are confusions that don't go to the issue of whether Mr. Einstein was actually there and whether there was potential fraud purported against the court below this court.
On the ultimate issue, assuming we get over all the waivers and the untimeliness, let's say, possible untimeliness of your putting forth these decisions, in order for you to win this case on this issue, don't you have to show by clear and convincing evidence that the process server was a liar?
Yes, we do, and we would have wanted to examine the process server, Your Honor, and that's what we asked for.
What stops you?
Well, we said, Your Honor, at the hearing below, we should bring, instead of Mr. Einstein to fly over here, it is the plaintiff, Baxter, who is claiming that their process service is correct. And once there's an issue, Your Honor, they have to address it.
That's not the way it goes. If you are attacking the return of service, no matter USA or Republic of Israel, it's your burden to show that he's a liar. And you didn't have any evidence to show that.
Well, we did have evidence, Your Honor, because his
no admissible
there was no objection as to the admissibility of the evidence below, and in fact, Her Honor below, she looked at the passport, and she may have made a decision based on that. But we came forward, Your Honor, I'd like to reserve 2 minutes for rebuttal. We came forward, Your Honor.
You're there.
Sir?
You're there.
The final statement regarding that, before I come to rebuttal, is that Mr. Einstein, Your Honor, said, okay, come on and just put me on a telecom, and we will do under the Florida rule, of Judicial Procedure 2.530, let's have a telephonic hearing where the question that you will ask Einstein is, where were you? Were you there? And corroborate with your testimony what was there. Thank you, Your Honor.